part heard appeal in the matter of South Bank Hotel Management Company Limited and Galliard Hotels Ltd and others.
Mr. Prohodiary.
Thank you, my lord. The second topic I wanted to move on to was the point raised by the respondents, which is that even if there was an obligation capable of contractual enforcement, it was not a continuing obligation, rather it was a once and for all obligation, or what I call a one-shot obligation. And to a certain extent, I've already met this point. In our submission, there is a need to give content and effect to Clause 9. If the obligation was merely a one-shot obligation, as the respondents suggest, it would be utterly devoid of content and effect. There is an authority I'd like to turn to, Bell and Peter Brown, which illustrates the distinction between a one-shot obligation and a continuing obligation. And that's in volume 2 of the authorities bundle, tab 23, page 443. The case will likely be familiar to the court. It was a professional negligence claim. A husband was divorcing his wife, and he conveyed the house to her. He intended to retain a 1/6 interest in the proceeds when sold, and so the solicitors needed to transfer the house subject to a trust deed and lodge a caution at the land registry. They didn't do so, and it was argued by the husband that the solicitor's duty to do so was a continuing duty. This was rejected by the court, and it can be seen why at page 443. This is the judgment of Lord Justice Nichols. Around letter F, he's gone through the steps that the solicitors ought to have taken, and then he explains, clearly all those steps needed to be taken at the time of the transfer, or, in the case of lodging a caution, as soon as reasonably practicable thereafter. When the solicitors failed to take those steps in 1978, he was thereupon in breach of contract. This was so even though the breach could be remedied. So that was an example of an obligation that had to be performed at a particular point in time. And then over the page, at around letter D, Lord Justice Nichols deals with the distinction between such an obligation and a continuing obligation. He states that the above observations are directed at the normal case, where a contract provides for something to be done and the defaulting party fails to fulfill his contractual obligation in that regard at the time when performance is due under the contract. In such a case, there is a single breach of contract. And then he goes on to say that there is a contrast with cases where, on a true construction of the contract, the defaulting party's obligation is a continuing contractual obligation. In such cases, the obligation is not breached once and for all, but it is a contractual obligation which arises anew for performance day after day. And so what that tells us is it's a matter of contractual construction. Is the duty a one-shot duty, as most duties are, or is it a continuing obligation?
And he uses the example of the repairing covenant.
Precisely, my lady, precisely. And in our submission, a contractual obligation to allow someone to grant someone the right to utilise something is necessarily a continuing obligation, because you don't want to utilise something one moment in time. You need to utilise it day after day.
Is there a distinction? The grant is once and for all, you do it once, but the nature of the right which you have created has to be continuing, and it has to, and the grantor has to preserve that right, or it's worth nothing.
Precisely, precisely. What they're granting is a right to utilise.
So they grant once, but what they grant, then the nature of what they're granting continues. Yes. You say.
Precisely, lady. That is our case. And in that regard, the judge identified a helpful analogy at paragraph 382 of his judgment. That's page 140 of the court bundle. middle of that paragraph he says, if 2 months later Galliard Hotels changed the locks to the annex and refused South Bank access, then Galliard Hotels couldn't be said to have complied with Clause 9. Which goes to my Lady Justice Asplin's point. They may well have granted it at the time of the lease, but if 2 months later they put locks on the door and prevent you from utilising it, it can hardly be said to have complied with their obligations. So we say the judge was right to find that it was a continuing obligation. And that brings us on to our ground of appeal, which is that though the judge found it was a continuing obligation, he found that there was no continuing breach. And our submission is simply this: once you have a continuing obligation, there is a breach each and every day that obligation is not met. And in this case, each and every day after the 16th of June 2008, Galliard Hotels did not meet their obligation to give South Bank the right to utilise the annex free of charge.
Sorry, so that's the date of the lease and underlease.
That's the lease, date of the lease. Underlease, yes. And we respectfully submit that the judge fell into error in a number of ways in his analysis. The first was at paragraph 383, so page 140. And he rejected our assertion that there was a continuing breach because he says in the middle of that paragraph, Galliard Hotels did nothing further to aggravate the situation after granting the lease, nor after the lease was granted was the situation more acute. 2 years after the lease was granted, and without any additional action on the part of Galliard Hotels, it was just as incapable of giving South Bank the use of the annex as it was on the day the lease was granted. And we say there's no basis in authority to suggest a need for aggravation or for making the matter more acute. All that is required is that you do not in fact perform your obligation on the given day.
Just thinking around that. You say there was a breach when the lease was granted.
We say the cause of the breach was the grant of the lease. So there was first a breach when the lease was granted, but the breach is not giving us the right to utilise the annex. Because with the grant of the lease, we can no longer lawfully do so unless we pay someone.
Yeah. So you say the mere grant of the lease before anything else happens is a breach.
Of course, there are ways that Galliard Hotels could have avoided the breach. So they might have granted the lease and then it imposes a condition of the lease that we should have the right to utilise the annex free of charge, so if the lease was on different terms, or granted the lease and then itself entered into an underlease and agreed to pay Lodgeshine the cost of us using the annex. But on the facts as we have them, the effect of the lease was that we no longer have the right lawfully to use the annex without charge.
I mean, you did for the first 5 years.
Yes, because the first 5 years of the underlease were rent-free.
Yeah.
Yes. This point about making the problem more acute or aggravating it can also be seen in the judge's analogy with the tenant's repairing covenant at paragraph 384. And he says that if a tenant who has agreed to a repairing covenant allows a property to fall into disrepair, it can quite sensibly be said that each year that passes involves a new breach, and it's a breach that makes the problem more acute. And we say the judge was wrong in his analysis there. It may well be true in some cases that a failure to repair makes the problem more acute. So, for example, if there's a hole in the roof which lets rain in, but in other cases, there may well be a breach of the covenant that doesn't make the problem more acute. So if you have a hole in a non-load-bearing internal wall, the hole's there, nothing's getting worse. It'd be surprising if one was a continuing breach and the other wasn't. So we say the judge fell into error in those aspects, his judgment. The respondents, for their part, say that a continuing breach requires a repeated activity. And there are two problems with that assertion. The first is that the cases they rely on in support of that proposition are simply not relevant to this case. And secondly, in any event, those cases don't support the proposition for which my own friends rely on. So the first case is Jalla, and that's in volume 4 of the authorities bundle, tab 53. And the facts of this case are it concerns an oil spill off the coast of Nigeria. Some 40,000 barrels of oil leaked from a pipeline operated by Shell over a period of 6 hours, and then the leak was stopped. The judgment proceeded on the basis that the claimant's case was true and that the oil had spread to the shoreline to devastating effect. And the claim was one in private nuisance. And the claim is relied on for the proposition that one needs a repeated activity before one can have a continuing breach. And we say the case is irrelevant and is of no assistance to the court because, quite simply, contract is different to tort. The tort of nuisance is fundamentally different from contract in all sorts of ways, but the most important is that by a contract, a promiser is able to voluntarily agree to do something that goes beyond duties imposed by the general law in tort. So if Jalla stands for the proposition that you need a repeated activity to have a continuing private nuisance, all that means is that the tort of a private nuisance requires an activity, and so for it to be a continuing tort, the activity needs to continue. You can't then transpose that across to the contractual situation and say that the same rule applies for all contracts. Rather, it's necessary to look at the content of the contractual obligation. So if my contractual obligation is to not allow oil to leak from my pipeline, then one might well see that for there to be a breach of that obligation, it needs to be repeated every day, for there to be a repeated breach, for a continuing breach. By contrast, if my contractual obligation is simply to grant someone a right to utilise my pipeline, if on day one for some reason I can't grant that right, the cause of me not being able to do so does not need to repeat each day for me to have breached that obligation. But secondly, and perhaps more importantly, Jalla and Shell doesn't even stand for the proposition that you need a repeated activity in the tort of private nuisance. Rather, the case tells us that you need a repeated activity or an ongoing state of affairs for which the defendant is responsible. And that can be seen in 3 places in the case. The first is in the head note. The second is paragraph 26 of Lord Burroughs' judgment, and that's at page 1654. In general terms, a continuing nuisance is one where there is repeated activity by the defendant or an ongoing state of affairs for which the defendant is responsible. which causes continuing undue interference with the use and enjoyment of the claimant's land. It can also be seen in the court's discussion of the Delaware Mansions case. And this is just on the previous page, 1653. This was a case where there was a tree on the land of Westminster City Council, and the roots of the tree were causing damage to a building, and there was subsidence to the soil, and the council refused to cut the tree down. Now, this wasn't a repeated activity. The tree was just there. It was an ongoing state of affairs for which the council was responsible. Nevertheless, there was still a private nuisance. And Lord Burroughs summarises the effect of that case at page 1655, paragraph 30. So we say Jalla is irrelevant, but even if it was relevant, it supports our position. The second case they rely on is Holden Chard. That's another private nuisance case, so I don't need to deal with it further. The third case they rely on is Spore and Green. And we say that that case simply stands for the proposition that the covenant for good title is not a continuing obligation. Rather, it's an obligation that, if it's breached, is breached once on conveyance. And in my submission, that's entirely unsurprising. If I'm contracting to convey land with good title, the time for performance is on conveyance. It's probably worth just turning up Spore and Green. It's volume 1 of the authorities bundle, tab 11. The passage I want to refer to is at page 143.
I'm sorry, I didn't hear the page.
143.
Thank you.
And this is the judgment of Baron Bramwell, which my learned friends rely on. And the bottom paragraph, he's talking about the breach of covenant for title. And then in the last few lines, he says, assuming the breach to be correctly stated and proved, I am of the opinion that the statute of limitations is a bar to it. It was completed if it ever existed at the time the deed was executed. And then over the page, he says it is not what is called a continuing breach, any more than not paying money is a continuing breach. The covenant remains broken indeed, but broken once and for all. And then he goes on to contrast that with the covenant for repair, where the breach is continuing. So we say Spore and Green doesn't support the respondent's case.
There's also references there to the covenant for quiet enjoyment.
Yes, but they found that the covenant for quiet, on the facts, they found that there was no breach of the covenant for quiet enjoyment.
I mean, that might be thought to be more akin to what we're dealing with.
Precisely, my lord. And indeed, in the, I referred to some extracts in McGregor in the skeleton argument, which established that the covenant for quiet enjoyment is a continuing obligation. It might be useful actually just to turn those up. So it's volume 4. page 1660, tab 54, 1660. And in the middle of paragraph 2817, the second covenant, which is the covenant for quiet enjoyment, operates prospectively, and there is no breach until some disturbance of the buyer's enjoyment of the land takes place, and it is a continuing covenant upon which damages may be recovered from time to time as they accrue. And just for your note, I won't take you to it, but the same point is made again at 2919. So drawing the threads together, once the judge had found that there was a continuing obligation, which he was right to do, it necessarily followed that on each and every day we weren't given the right to utilise the annex free of charge. There was a breach. Which takes us on to the last point, which is the respondent's case, that we have suffered no loss. And we say the position here is, again, quite simple. It's entirely conventional that the victim of a breach of contract can get compensation reflecting the cost they have been put to in procuring the thing that had been contractually promised. So, to be able to lawfully use the annex from the time the lease was granted, we had to enter into the underlease and in due course pay rent pursuant to the underlease. And if we hadn't done so, we would have been liable to pay Lodgeshine mean profits for trespass. And that is our loss, obtaining alternative performance to that which had been contractually promised. That's all I have to say on the continuing breach point. I think Mr. Willan has a few points to wrap up from yesterday, unless I can be of any further assistance.
Thank you very much.
Thank you.
Mr.
Well,
Willan.
ultimately, can I just hand in the homework that I was set yesterday, and I will start with the structure chart if I can, which has been agreed with my learned friends. Can I just mention, it's been helpfully drawn to my attention by Mr. McLaughlin that something that I've said in my skeleton is therefore wrong as a matter of fact. Inconsequential, but just so that you have the position entirely correctly. At Galliard Homes, you will see there are 4 directors. That's the company in the middle of the chart, if I can put it that way. Mr. Conway, Mr. Angus, Mr. Ramjan, and Mr. White. In my skeleton, or our skeleton, we omit Mr. White and we include someone called Mr. Huberman. He comes in later. He is, I understand that Mr. White was in fact a chartered surveyor, so the points I made yesterday about having 3 professional people stand, but it was in fact at the time Mr. White and not Mr. Huberman.
And just so I know where in your skeleton that's misstated, where is that?
Paragraph 96. Can I then hand up Schofield and Schofield, which my Lord will Justice Newey drew attention to? And my Lord was correct that the Court of Appeal, through Lord Justice Etherton, approved what he had previously said in Rolfe and Rolfe, and that's at paragraph 32. So this was a geometric case about whether a particular informal meeting was sufficient to take effect. In paragraph 32, Lord Justice Etherton says that what the authorities show is that there must be an effective agreement to treat the meeting as valid and effective, notwithstanding the lack of required notice. Lease agreement could be expressed or by implication, verbal or by conduct, given at the time or later, but nothing short of unqualified agreement, objectively established, will suffice. The need for an objective assessment was well put by Mr Justice Newey in Rolfe and Rolfe, and then the passage that I referred to yesterday about the need for formality and otherwise the difficulties of companies changing hands and it being impossible to verify what the position was. And so we say that principle plainly applies here, and the mere fact that Mr Conway may internally have thought what he was doing was fine can't constitute a ratification by Galliard Hotels, absent some objectively verifiable conduct on the part of that company. The final two things I then need to hand up are just to deal with the point about availability of equitable compensation. And that is an extract from Snell and a first instance decision in PNC Telecom. So starting with the extract from Snell, this is from a section, as you can see at the top, it's from section 6, remedies for breach of fiduciary duty, subsection 5, equitable compensation for loss. And under the heading availability, it states a principal can also claim equitable compensation for loss caused by a breach of fiduciary duty, whether it occurs by reason of a conflict between duty and interest, or a conflict between duty and duty. And then there's some discussion that goes on in relation to that. It's pointed out in the final paragraph of that section that where the fiduciary does occupy a steward-like role, so for instance, whether a trustee or director, an award of equitable compensation can be made against the fiduciary to recover funds or property which has been misapplied. This claim is more in the nature of a claim to restore the property than a claim for equitable compensation for loss. But nonetheless, that is a restorative remedy, not a profit-based remedy. And certainly Snell seems to take the view that there is nothing unique about a conflict of interest which excludes the possibility of equitable compensation. It is fair to say, if one looks at the cases footnoted at 654 and 655, none of those 654 and 655, which is none of those cases, so far as I can see, has anyone expressly raised the question, is this possible, and expressly resolved it. And I think as a matter of duty, if nothing else, I am aware that there is a 2003 Court of Appeal case, Gwembe Valley, in which the court expressly decided to leave open the question whether it was possible to have equitable compensation for a mere failure by a director to disclose interest, although then referred to an article by Matthew Conaglan, which the Court of Appeal observed contained arguments both on authority and principle why a remedy of equitable compensation should be available in such a case. But recognising that the point has not been expressly addressed, one can, however, see it being done in practice. And so, for instance, in the PNC Telecom case, which I've handed up, just to give you the facts of what was going on, and that the relevant facts really start at paragraph 51. but if I can summarise them this way, there was a gentleman called Mr Thomas who was a major shareholder in an AIM-listed company and also one of its directors. As paragraph 51 explains, he was looking to sell his shares in order to bring in a new money effectively. So the company was distressed, and so he wanted to bring in a company which could, as it was put, return the company to being a viable, active trading company. And Mr Etherington was interested in investing, and he was going to do so through a company in which he had a 50% interest called Snapper Seafoods. Paragraph 53 explains that there was then a deal done between Mr Thomas and Mr Etherington, which is that Mr Thomas would sell his shareholding at market value, and Mr Etherington would come in and be in control of the company. So Mr Thomas would depart and Mr Etherington would come in, but for various reasons there was a delay between the two things happening. So Mr Thomas sells, Mr Etherington comes in sooner than Mr Thomas sells his shares. Mr Thomas, as part of this arrangement, and you see this at paragraph 56.3, votes at the board as director for an arrangement that brings Mr Etherington in as chief executive, company secretary and general legal counsel for a salary. But 56.3 explains that that was done on terms that had a change of control provision, which meant that if Mr Etherington was removed, he would get paid all of his outstanding sums under those terms of appointment. And then just to see how that plays out in terms of the breach, going on to paragraph 86. The judge finds that he was bound to conclude that Mr Thomas was in breach of fiduciary duty. That was because the change of control provisions were part of the wider arrangement, including the sale of Mr Thomas's own shares, and indeed Mr Etherington wouldn't have bought without the change of control provisions, thus in a clear position of conflict between his personal interest, I impose the word personal, in selling his shares to Mr Etherington, and his duty to consider the change of control provisions solely in the company's interests. So the finding of a breach of the conflict rule, no finding, as far as I can see, of bad faith, because in a sense he was doing it in part at least for the benefit of the company. In paragraph 88, the judge rejects any claim for secret profits. It was being alleged that he'd made a personal profit by selling at above market price, and that was rejected. But at paragraph 89, the judge awards equitable compensation equal to the amount of the payments made pursuant to the change of control provisions. So not a profit that Mr Thomas has made, but a sum that the company has paid to Mr Etherington under a transaction which the company concluded in circumstances where Mr Thomas had voted while subject to a conflict of interest. So although I can't say that the point was argued there as a matter of principle, certainly there are authorities where equitable compensation has been awarded for a mere breach of the no conflict rule. Unless I can assist further, that completes our submissions.
Thank you very much. Mr Trumpeter.
Yes, my lords, my lady, just on that little extra clip of authorities, I received those shortly before 10 a.m. I haven't yet had a chance to consider, so maybe I'll have to pick that up in reply. If I may.
Yes.
Like my learned friend, I'm going to deal with the limitation grounds and the validity grounds, and my learned junior, Mr McLaughlin, will deal with the room lease claim. Could I begin with something to say about the facts? Because my learned friend skillfully opened the appeal yesterday with some limited, and I would venture to say tendentious reference to the judge's findings in an effort to present Mr Conway as someone who acted with conscious impropriety, eager just to line his own and his family's pockets. And in my respectful submission, it's worth spending a few moments looking at the judge's findings in order to understand how the Annex Lease Scheme, as it has been described, also somewhat tendentiously, came into existence. So can I take you, please, to the core bundle at page 69, picking up at paragraph 36 of the judgment. And we can see there reference to an original planning permission called the 300-room proposal, which included a class B1/D1 element, which, as you can see from the indented quoted text, related to an additional standalone offices or consultation office. And in paragraph 37, there's some explanation for that, that the 300-room proposal included a bolt-on annex pulled away at ground level. And if one goes down a few lines, you'll see a description that the annex would have its own entrance from the street and would in appearance be a separate building from the main hotel. And he goes on to say a couple of lines on, there was no internal access between the two buildings, even at first and second floors where the annex and hotel abutted each other. The floor levels and ceiling levels were different. It was envisaged to have a separate postal address with separate sewerage connections from those of the hotel. And if we can go over the page, please, to page 70, paragraph 40, there was subsequently, in February 2004, a second planning commission, this one a 394-room commission, but still retaining the class B1 or D1 element pertaining to the annex. Next, we can go, please, to page 76 and paragraph 75. And the judge observes at the beginning of that paragraph, the FSC, with which we are now all concerned, was prepared in a rush. And it was prepared in a rush for a sales event in Hong Kong, as you can discern from that paragraph. And on the next page of the judgment, at paragraph 77, the judge explains why such an important document was prepared and executed, as he put it, in relatively short order. And he explains that the answer, 3 lines down, is that in February 2004, it wasn't perceived as an important document at all. And then he goes on to explain why that was the case. And in a sense, that's unsurprising because from Mr. Conway's perspective, he was, like you would do in a residential development, selling what is akin to flats off plan, but it just happens to be room leases. And the investors would no doubt be particularly concerned with the income they get from their individual rooms, just like a purchaser of an off-plan residential flat for investment purposes is concerned about the rent they get from the flat. That's the key aspect of the investment. A little bit further on in the judgment, if we go to page 81 of the bundle, please, at paragraph 103, we see importantly beneath the heading, the introduction of Park Plaza, some findings about the involvement of a hotel operator. You'll see at paragraph 103, in March 2005, Mr. Conway has lunch with Mr. Ivisha, who is head of the Park Plaza Hotel Group. And Park Plaza agrees to become the hotel operator. And it's in that context, at paragraph 104, 3 lines up from the bottom, that in May 2005, Mr. Ivisha indicates to Mr. Conway that if Park Plaza was to operate the hotel, it would wish to locate certain communal facilities in the annex. And one sees again in paragraph 105, 3 lines up from the bottom, Park Plaza came to believe that the hotel would also benefit from additional conference facilities on the upper floors of the annex. Then, if one goes to the following page, 82, this is what leads to a change as paragraph 111, as the judge describes it, in the way that Mr. Conway viewed the annex. And as he describes it, until then, the annex had been a drawing in an architect's plans. And a little bit further on in that paragraph, the discussions with Mr. Ivisha showed Mr. Conway that, one, the annex now needed to be used as part of the hotel, and two, Galliard was being put to expense in consequence. And just pausing there, that's because in order to incorporate the annex, there would be the construction costs. You have to break down the walls, you have to level the floors, and there were associated changes as well that we'll come to, including the increase in the size of the basement that sat underneath the hotel and the annex building. So Galliard is going to be put to an expense in incorporating this annex, and then also at 3, investors would obtain some benefit from that expense. And that's for an obvious reason, because if the hotel has attractive amenities, it means guests are more likely to stay there. And if guests are more likely to stay there, then they're more likely to stay in your rooms, and you'll get a more confident income stream from your investment. And the judge describes at the top of page 83 how Mr. Conway didn't have an understanding of the detail of the transaction, but the outcome, as the judge has put it, jarred with his understanding because he didn't think the annex formed part of the investment proposition to the investors. But it's that discussion with Mr. Ivisha which then leads eventually to 2 further developments. One is at paragraph 115. You'll see there's reference to something called a 396-room scheme, which involved a considerable extension to the basement of the hotel. That's 3 lines up from the bottom. Planning permission was never secured for that scheme, 116, because in effect it was overtaken at paragraph 117 by what was called the 398-room permission. And that permission, as the judge describes it, effectively incorporates aspects of the 396-room scheme, including the extended basement, overlaid with changes that Mr. Ivisha had requested. And it's at that point, as one goes over the page to 84 in the bundle, Little Roman 3, you see the change of use from the annex, from former offices and consulting rooms into Class C1 hotel use.
And I don't suppose this really matters, but this is for retrospective planning permission, so it's already been constructed in the way in which we now have it.
Yes, that's right. I think as at September 2007, I think it's right that the annex had, as a matter of fact, been incorporated into the main hotel.
Yeah.
But it is relevant then, one looks at the observations in paragraph 119 at page 84. There was a disagreement between the parties at trial as to whether the annex resulted in increased amenities, as my side argued, or reduced amenities. And the judge thought that my side's argument prevailed, and he explains reasons for that. He adds at the end, Mr. Conway genuinely and reasonably thought, this is 4 lines up, that inclusion of the annex would improve the economics of the hotel to investors' benefit. Indeed, that was one of the reasons why incorporation of the annex into the hotel jarred with his high-level understanding of the transaction. And of course, there was no obligation on Mr. Conway's part to improve the amenities of the hotel. That didn't form any part of the suite of contractual documentation that the investors signed up to. But having discussed matters with Mr. Ivisha, he wanted to ensure that there was the best offering possible for the investors so that they could maximise their returns. And indeed, there's never been any criticism from any investor, at least not so far as I'm aware, that the investments themselves were bad or they didn't get a good return on their releases. Could we then please pick up the memo at page 85, paragraph 124. My learned friend yesterday took you to this. It's the April 2008 memo. And if one looks at the text of the quoted indented text, you'll see towards the end, Mr. Conway asks his solicitor, to whom this memo is addressed, I wonder whether it's too late to contemplate actually rentalising the annex building. The reason he wonders that is because, as he describes at the beginning of the memo, when we sold the hotel rooms, ... the side access building was always staying out of the equation and was a building worth several £100,000 for us either to occupy as office or let. And just in passing, at trial, it was suggested, and you see this from the bottom of the page, paragraph 125, that the memo was some after the event dishonest attempt to spin the facts to persuade Mr. Phillips, the lawyer, to issue advice to the effect that Galliard could indeed retain a rental stream. And the judge rejected that suggestion. One sees at the bottom of page 86, paragraph 131, where he says, I reject Southbank's arguments that the memo was a fundamentally dishonest exercise in revisionism. Mr. Conway was aware that there were issues associated with his proposal to rentalise the annex. However, that's why he sought advice on it. If Mr. Conway had truly wished to appropriate an annex to his own use, knowing he wasn't entitled to it, he could have done so much more straightforwardly by not asking for advice at all and bypassed Mr. Phillips' extensive knowledge of the project and so forth. And you'll appreciate Mr. Phillips was the solicitor who had set up the paperwork in the beginning. And he was there. He was the long-standing lawyer for the Galliard parties. And so those are obviously the actions of an honest man concerned to find out from his solicitor whether what he would like to do could lawfully and properly be done. If we then pick up, please, a little bit later on in the judgment now, at page 93 of the core bundle, paragraph 164, there's a series of important findings. 5 lines down in paragraph 164, you see the judge accepts Mr. Conway's evidence he didn't know of the FSC at the time he approved of the Annex Lease Scheme, but he had some awareness in general terms that there was a contract that would otherwise operate to transfer the whole title. So he didn't really know the ins and outs of how the transaction was structured. Then we get to 165. The judge didn't think that Mr. Conway's evidence about a mistake was problematic. Rather, as he goes on to say, it was consistent with his approach to matters of detail for Mr. Conway to form the view that to the extent that Southbank was to obtain the full economic interest in the annex, that was undesirable and at odds with his appreciation of the transaction. And so that then explains the mistake as he describes it in paragraph 166. And perhaps if I could just invite my lords and my ladies to read the first couple of lines and the last 3 lines of that paragraph.
Yeah, we'll do that.
And then...
sorry, if you'd like us to read them, we better just do that.
I'm so sorry.
Yeah.
And then at 167, the judge concludes it was reasonable for Mr. Conway to have formed the belief he did. And he explains why, 1, 2, 3, 4, 5, 6 lines down in paragraph 167. He says it was reasonable because the deal that had been done in 04 could be understood at a high level of generality as a transaction involving a hotel and a freehold interest in a hotel. But the annex couldn't be, at that time at least, couldn't lawfully be used as a hotel and was a separate building. And that's why it wasn't unreasonable for Mr. Conway to conclude that whatever the legal documents might have said, they ought not to treat the annex as part of the deal. I'm now on page 94 of the bundle. And I want to pick up, if I may please, at paragraph 169, where it is said that Mr. Conway both genuinely and reasonably formed the view that Mr. Phillips had advised that the Annex Lease Scheme was an appropriate way to prevent a mistaken transfer of the annex. And what's more, he also genuinely and reasonably formed the view that Mr. Phillips had advised that that would not involve Galliard Hotels in a breach of trust or breach of contract. So that was his understanding of the advice that was given by professional, competent solicitors, that there was no, or wouldn't be, a breach of trust or breach of contract. And indeed, there was nothing in the advice given by Mr. Phillips, and there were no findings by the judge, that Mr. Phillips advised otherwise. And in consequence of that, paragraph 170, at the bottom, 3 lines up, Mr. Conway concluded reasonably that if there was anything wrong with the Annex Lease Scheme, Mr. Phillips would have thought that. And so therefore the judge rejected at paragraph 171 Southbank's assertion that Mr. Phillips told Mr. Conway that the scheme would likely involve some kind of breach of the FSC, but Mr. Conway decided to go ahead regardless. And then also, because this is relevant in the context of concealment and some submissions made yesterday, paragraph 172 is the judge rejects the assertion that Mr. Conway decided not to tell investors about the scheme because he knew that it was wrong. He thought, and you see this 4 lines down, that the Annex Lease Scheme was permissible. He just decided not to make a general announcement about it because he thought that might give rise to some mischief. On this same subject, if one goes to page 110 of the bundle and picks up at paragraph 240, there is reference to the fact that Mr. Conway accepted that he concealed the Annex Lease Scheme. But as the judge goes on to say in the second sentence, and I respectfully endorse it, one has to be very clear about what he meant by that. And we know what's meant by that at paragraph 240 on the next page. It was simply and no more than a decision not positively to, and I put the word positively as my gloss, but not positively to inform investors of the scheme. It was no more than that. And on the contrary, you see at paragraph 243 that no steps were taken in 08 to hide the scheme. And on the contrary, both the lease and the underlease were registered for the whole world to see, including, of course, those investors who purchase room contracts after the date of the lease and the underlease, because there was still sales ongoing. Their conveyancing solicitors may well have looked at the titles and seen that the underlease and the lease were registered. So there was no attempt to hide the scheme in any way. All that Mr. Conway did was not publicly announce it. For completeness, can we also then go, please, to paragraph 246, page 111. In February 2013, halfway down this paragraph, Galliard appoints a company called C1 Capital to protect investors' interests by overseeing decisions regarding the operation of the hotel. And there was a person we'll see in a moment called Mr. Dykstra who acted for C1 Capital. He was effectively a kind of asset manager or hotel operator kind of person. We then go to the next page, paragraph 249. We see that investors are issued their shares in March 2014, at which stage, had they wanted, they could, of course, have taken control of the board of Southbank, but they didn't do that. But as it so happens, you see at page paragraph 251, in April 15, one of the investors is appointed to the board. That's a Mr. Marley. And significantly, Mr. Marley was free to ask for whatever financial information about the hotel he wanted. And I say that's significant because if one goes to page 114, you can see a record at paragraph 258 sub Roman 2 of Mr. Marley in 2017 requesting some financial information for Mr. Dykstra. He's the C1 capital person. And he was then sent some management accounts showing that South Bank was paying just under £10,000 a month as rent on the underlease. And the judge, with respect, rightly observes, after the reference to hotel property lease, if the defendants were orchestrating an ongoing programme of deliberate concealment, they would have ensured that Mr. Dykstra was instructed not to reveal such information. So I think that's what I want to say about the judgment at this stage. But I think it's really important to bear those facts in mind, because what this court, in my respectful submission, should do is reject out of hand the unspoken thesis that underpinned so much of my learned friend's submissions yesterday, that Mr. Conway is guilty of some kind of conscious impropriety, so that common sense dictates that the judge's conclusion was wrong. My lords, my lady, I now want to move on to the limitation grounds, and I'm going to begin with some introductory observations, which I'll split into three parts. First, look at the statute, then look at how the case was put at trial, and then look at how the case is put on appeal. And once I've done that, I'll go through the grounds in turn. So let me start with the statute. So this is in the authorities bundle, I think volume 1, tab 3, page 15. In my submission, probably the best place to start is section 21.3. One can see from that provision that it contains, subject to the preceding provisions, a general 6-year limitation period to actions by a beneficiary to recover trust property or in respect of any breach of trust. And one can see that the language of section 21.3 to some degree reflects or mirrors in reverse section 21, because it talks about an action by a beneficiary to recover trust property, which is similar to the language of section 21.1b, and then an action in respect of any breach of trust, which is similar to the language in 21.1a. As I say, section 21.3 is subject to the preceding provisions of this section, and of course that directs us to section 21.1, with which we are particularly concerned. And that provision explains that no period of limitation prescribed by this Act shall apply to particular types of action by a beneficiary under a trust. Now, pausing there, there is a definition of action in section 38 of the Limitation Act, which is a few pages on in the bundle, page 18. Section 38.1 states that unless the context otherwise requires, action includes any proceedings in a court of law. And I venture to say, if one goes back to the provision itself in section 21, that the reference to an action in this context is very important. And it's important because the system of limitation under the Limitation Acts is based upon the nature of the action, not on the remedy or anything else. And I'll expand on the relevance of that a little bit later on, if I may. But it's really important to keep that in mind. Sticking with the wording of the statute for a moment, the two types of particular actions with which Section 21 are concerned are then prescribed in A and B. Subsection A is no longer relevant. That's fraud or fraudulent breach of trust. We are concerned with B. So that is an action by a beneficiary under a trust to recover from the trustee trust property or the proceeds of trust property in the possession of the trustee or previously received by the trustee and converted to his use. Now, as you, my lords and my lady would have picked up from the skeletons, the expression trust and trustee in Section 21(1) is defined again in Section 38 of the Limitation Act as having the same meaning as in the Trustee Act 1925. I don't think I need to take you to that. And then in turn, the Trustee Act 1925 makes clear that the expressions trust and trustee extend to implied and constructive trusts. And the nature of the constructive trust to which the Trustee Act refers was, of course, considered fully by the Supreme Court in the Williams and Central Bank of Nigeria case, which is very well known, but nonetheless is probably worth looking at very briefly. It's behind tab 36, which I think is in your volume 2. It's the last tab in your volume 2. And one can pick up the judgment of Lord Sumption at page 774, and he summarises the alleged, albeit at that stage contentious, I think this was a summary judgment appeal, facts between letters B and C. And in short, Dr. Williams claimed that he was a victim of fraud and he had been induced to serve as a guarantor of a bogus transaction. He paid $6.5 million to a solicitor called Mr. Gale to be held on trust. And Dr. Williams said that in fraudulent breach of trust, Mr. Gale, knowing certain funds weren't available, paid out $6 million to an account of the Central Bank of Nigeria, and he pockets the remaining $500,000. And Dr. Williams says that the Central Bank is a party to the fraud. So that's essentially what the case was about. If one then goes to page 776, paragraph 9, having referred to the famous statement of principle of Lord Selborne in Barnes and Addy, Lord Sumption describes two types of constructive trustee, really reflecting the distinction recognised by Lord Justice Millett in Paragon and Thackeray. The first type of constructive trustee, and this is between F and G, comprises persons who've lawfully assumed fiduciary obligations in relation to trust property, but without a formal appointment. And one then can cast your eye down to letter H, where he explains that company directors are, by virtue of their status, fiduciaries with very similar obligations. And I think it's common ground that company directors are treated as constructive trustees of this first type. And then the second type of constructive trustee, after the sentence I've just taken you to, it refers to something else. It comprises persons who never assumed and never intended to assume the status of trustee. And by letter B on the following page, Lord Sumption explains these can conveniently be called cases of ancillary liability. And the relevance of this to limitation is picked up at page 778 of the bundle, just before paragraph 12. There's a section, relevance of the distinction. I think for present purposes, it will suffice if I pick up at paragraph 26, all the way at page 785. Just after letter C, 2 lines down, Lord Sumption says, by adopting the meaning and not just the language of the definition of the Trustee Act, Parliament made it even clearer that the intention was simply to cover de facto trustees. The Trustee Act is concerned with the administration of true trusts, not concerned with constructive trusts imposed by equity on strangers to the trust in the exercise of its remedial jurisdiction. So that's the central point about understanding the difference between the two types.
I really don't think it matters. Well, as far as I know, it doesn't matter for this case, but I do wonder whether the Paragon distinction works in quite the same way post FHR and other cases, which imply that there are true trusts where there might not otherwise have been thought to be true trusts. But that's, I think, irrelevant for this purpose.
I suspect, at least for the purposes of my submissions, I don't think that point does have a relevance, but it may be, as I expand on what I have to say, my Lord thinks differently, in which case I'll obviously be happy to try and address the point. Before I move away from reference to the statutory provision, can I just say something briefly about purpose? Because yesterday my learned friend placed tremendous reliance on what he stated to be the purpose of section 21(1)(b), and in consequence, that purpose ends up doing a lot of heavy lifting for my learned friend's submissions. What I'd say about that is one has to be a little bit cautious when relying on purpose, and for 2 reasons. One reason is a little general, and one is a bit more specific. The general reason is that... I'm so sorry.
Excuse me, just a
I'll wait for the lady.
I'm sorry to have interrupted. Yes, purpose.
Yes, and I was explaining why one needs to be a little bit cautious when one relies upon purpose. The general reason is that it is obviously important when interpreting a statute, I accept, to have regard to its purpose. That is well established law. It's repeated very high authority to that effect. But nonetheless, the start point has to be the wording of the statute itself. So what the court has to do is look at the grammatical and ordinary sense of the words and try to adhere to those words in a way that is consistent with the purpose that underpins the provision. So that's my general point. My more specific point is this. One can discern from the Limitation Act, and indeed from Section 21 itself, that there are actually competing purposes within the provision. On the one hand, you have Section 21(3), which is there for the purpose of upholding, you might say, the public interest in barring stale claims. That is a very important purpose that pervades the Limitation Act and is indeed why it's there. But on the other hand, Section 21(1) is there for the purpose of allowing some limited derogation from that public interest that is expressed through Section 21(3). And what I would suggest is that neither purpose is more important than the other. Rather, what the court needs to do when construing Section 21 against Section 23 is to consider the 2 competing purposes and work out a way that they can harmonise with each other within the operation of the provision as a whole. So that's what I want to say about Section 21(1)(b). Next, I'm going to move on.
Can I just ask you a question arising out of something you said about subsection 3?
Yes.
That draws this distinction between an action by a beneficiary to recover trust property or in respect of any breach of trust. And then if you go back to subsection 1(b), which is to do with recovering trust property, just in terms of the wording of the statute, it doesn't seem to require there that there's actually been a breach of trust, whereas little a does.
Well, I think in my submission that there has to be, and I think that this was a point that my Lord raised with my learned friend yesterday, and I think he accepted as much as well. And the reason there has to be is because of the concept of an action. because these the words in 1A and 1B don't appear in an acontextual vacuum. They are linked to the reference to a particular type of action by a beneficiary under a trust. So if you don't have an action, let's say you don't have a legally recognizable, cause of action against a trustee, it's very difficult to see how that can be an action under section 21(1) A or B, because it just won't be. It will just be a generalized complaint about something. And so in order to bring yourself within 21(1) A and B, there has to be, in my respectful submission, an action which must mean a legally recognizable action. And in this context, it must involve a breach of trust by a trustee.
Well,
Sorry, go on.
no,
No, please.
sorry. I'm just wondering about that, whether you might have an action brought by a beneficiary of a trust just saying, I am entitled to trust property, please hand it over to me. And the trustee may very well be able to say, well, I'm not sure about that. And the not handing it over to the beneficiary may not constitute a breach of trust, but it's nonetheless an action for the recovery of trust property from the trustee.
Yes.
And in that, sorry to chip in, and in that regard, you put a lot of emphasis on action in sub 1, but there is the distinction in A, which expressly refers to breach of trust, and B, where it does not.
Well, I accept that's entirely, if I may respectfully say, entirely fair observation. But even in my Lord Justice Miles' example, there would be a breach of trust, I think, because you have a situation where a trustee holds assets on trust for a beneficiary. I appreciate in the example we haven't quite explored the nature of the trust, but I'm assuming it's possibly a bare trust, and it means then that the trustee in that example would be obliged, I think, to convey the trust property to the beneficiary if requested to do so, and the refusal to do so would amount to a breach of trust. But I mean, perhaps I can put it this way. I'm not sure, again, it really matters for the purposes of this appeal, because one thing is clear, and I hopefully tried again to develop this, that the liability that South Bank is looking to impose on Mr. Conway in connection with the grant of a lease is not a Class 1 type liability within the meaning of the discussion in the Williams case. It's what you might more properly describe as an accessory or an ancillary liability of Class 2 type. Which
Is that right?
Well,
I understood them to be saying it was a Class 1 claim, but I may have misunderstood.
No, absolutely. No, South Bank maintains it is a Class 1 claim, and I'm suggesting respectfully that that is not right, that actually this is properly understood a Class 2 claim, because Mr. Conway, with his South Bank director hat on, effectively didn't do anything as regards the lease. And obviously I'll try and expand on that when I get to it. And that's why I say ultimately, whatever the outcome of the debate we're just having, I'm not sure it really matters for the purposes of this appeal.
But does that then raise Lord Justice Newey's question about whether that distinction which is drawn between Class 1 and Class 2 remains a real one, where it's been held that where a fiduciary benefits from a breach of trust, a breach of fiduciary duty, the property becomes subject to an actual real trust. It's not just, as it were, a remedy.
Well, again, I don't think it matters, because again, when one looks and tries to unpick ground 1, what they are concerned with is the grant of the lease, which, as I say, is you know, I'll try and take it in stages. I'm very happy. If my Lord would like me to deal with it now, I'm very happy to. But the point is the complaint is, or if you like, the trust property that the South Bank is looking to recover, as I understand their case, is the beneficial interest in the freehold. And they say, I think, that that was converted by the grant of the lease. And as I said, that's just independent of and unrelated to anything that Mr. Conway does or might be taken to have done with his South Bank trustee hat on. It doesn't involve his custodianship of trust assets in any way whatsoever.
Is that right? I mean, there may be different ways in which the complaint is put. One thing we were shown was your pleading that South Bank consented. Well, that would involve Mr. Conway as a director of South Bank causing South Bank to consent. So that would be done in his capacity as a director of South Bank. Then alternatively, it said, well, somebody, well, there are various ways in which it might be run, but one way is Mr. Conway wasn't focusing on the individual interests of South Bank. Therefore, you apply a charter bridge approach and ask what the independent director might have done, and the independent director might have done something to stop this transaction. Or again, it said, well, Mr. Conway was in a position of conflict insofar as he was a director of South Bank, and that leads to consequences. I mean, all these things are complaints about what Mr. Conway does or doesn't do in relation to property of South Bank, namely its rights under the contract.
Yeah, that is in a sense right, and obviously I'm going to do my level best to deal with all of those points. One, I suppose what I want to impress on my lords and my lady is that to the extent that there's any property that's held on trust at the point in time when the lease and the underlease are granted, the grant of the lease, in my respectful submission, doesn't interfere with that property. So,
well, I mean, this is sort of what the judge says, yes. But just looking at it more broadly, I mean, there's a danger of confusing two different sorts of trust here, isn't there? There's the trust of the land, if that's properly seen as a trust of the land arising under the specifically enforceable contract. And then separately, and this is the one we're really worrying about, I think, what is treated as the trust of the company property.
Yes. And
the complaint has to be about what Mr. Conway does or doesn't do in relation to the company's property, which is its rights under the contract.
Absolutely. I agree with that. And I understand that distinction. And what I'm saying is that actually that complaint doesn't arise because the grant of the lease is, as it were, independent of Mr. Conway's custodianship or deemed custodianship of that latter type of property, as I will try to, as I said.
And it's probably not worth exploring now, but I mean, I quite follow in causing Galliard Hotels to enter into the lease. He's acting as the director of Galliard Hotels. Yeah. He's dealing with that. But the complaint is brought by South Bank, and so we are concerned with what Mr. Conway does or doesn't do as a director of South Bank in relation to South Bank's property.
Correct. And
then the judge says, well, South Bank's property isn't affected, and the appellants say, no, that's not right.
Yeah. And as I said, and I'm going to obviously try to persuade my lords and my lady that actually the judge's approach is correct. And even if it's not correct, there's other reasons why it can be sustained in any event.
Yes.
But so just before I get on to that, I think it is helpful. I'm grateful for the interventions, but I think it might be helpful just to spend a couple of moments looking at how the case was developed at trial, because that helps to understand why the judge decided the case in the way he did. If one picks up in the core bundle the pleadings, starting at page 257, you see paragraph 39A, there is the plea of a limitation defence on the part of Mr. Conway. That is then responded to at page 297. At paragraph 17, where there's a kind of concatenated pleading addressing not only paragraph 39A that we just looked at, but a whole load of other paragraphs as well, where limitation defences are raised, albeit without seeking to distinguish between those paragraphs. And you'll see at 17.2, the claimant simply relies upon various provisions of the Limitation Act, but doesn't in any way explain how those provisions are engaged or said to be engaged. And perhaps unsurprisingly, given the importance of limitation to the proceedings, that was something of which the judge was critical. So if we can then go to the judgment, please, at page 131, paragraph 335. The judge first sets out the ingredients of section 21(1)(b), and he explains in Roman 2 how section 21(1)(b) has 4 possible permutations. And then at 3381 on the next page, I'm so sorry, 3382, page 132, the judge observed that South Bank didn't clearly articulate in its pleadings which of the 4 permutations were relied upon and what precisely was the trust property and so forth. And in that same paragraph, a couple of lines on, the judge references a speaking note. And that speaking note is to be found in the supplementary bundle at page 91.
91.
91, I think.
Thank you.
And it was produced on Thursday, the 11th of July, 2024, which was the penultimate day of trial.
Sorry, Thursday, the 11th of July.
Yes. And as it happens, there's a very small error on the front page of the judgment. It says the last day was on the 15th of July, which was a Monday. In fact, the last day was the 12th of July, which was a Friday.
Sorry, let me just correct that. So that should be the 12th of July, Friday.
Yes, everyone finished oral closing submissions on Friday.
Yes, I see.
No one had any appetite to go into the following Monday. So this document was produced on the 11th of July itself. We can see from the end of that document, so very late in the proceedings. And if one goes to page 97 of the bundle, one can see question 7. And there's some italicized text setting out some questions from the judge that he wanted some assistance with. He asked, what precisely is the property that South Bank seeks to recover? And then he asks, once the property is identified, please explain ... why that property was or was not in possession or previously received, etc. And in response to that, under 18 and 19, one can see that at that stage at least, South Bank's position was that the property or the relevant property was the lease. See at 19.1, the lease is the trust property, or 19.2, the lease comprises the proceeds of trust property. And then what the speaking note does is address the positions of Mr. Conway and separately Galliard Hotels. And as for Mr. Conway, you see at paragraph 20, it is said the lease is in Mr. Conway's possession because. And then paragraph 21, it begins, the lease was also previously received by Mr. Conway and converted to his use. And it gives reasons for that, beginning at 21.1, describing how the equitable interest in the annex was South Bank's property, etc. And so at that stage, as I think we had understood the case, South Bank was really articulating a Section 21 1B case, identifying the lease as the relevant trust property, or perhaps the proceeds of trust property. And so that then helps to understand the judge's judgment. If we go back, please, to page 132 in the core bundle, towards the bottom, you see paragraph
Sorry, I wasn't keeping up with the paragraph.
339, page 132.
Yeah.
Sorry, I'm rattling on at a pace. I do apologise.
No, well, yeah, I think you're quite right because we haven't got that much time, so I'm not complaining at all.
339, page 132, the judge describes how South Bank's position, as set out in its oral closings and speaking note, is that for the purposes of the breach of trust claim, that's against Galliard Hotels, the relevant property is the lease. And the judge then rejects that argument for the reasons which follow. And I'm not going to spend time looking at that. And then we get on to 134, page 134, and paragraphs 3, 4, 5, where the judge thought that South Bank's position appeared to be that the relevant property in relation to the claim against Mr. Conway was also the lease, which is really exactly what the speaking note says. And the judge then rejected that argument for the reasons given in 346 and 347, in respect of which there's no challenge in this court. And then at 348, what the judge did was to discern from the speaking note a slightly different argument, which is really the argument now, I think, that South Bank is looking to run on appeal, as you see it described in Roman 1 and Roman 2. And then there are submissions in 349, which effectively weren't contradicted. You can see at paragraph 350 in the passages that you, my lords and my lady, have already been taken to. Just in passing, I think this is perhaps relevant. In 349, you can see 1, 2, 3, 4, 5 lines down that South Bank's complaint is not that it no longer has a freehold interest in the site, but rather that since the interest is encumbered, its interest is less valuable. So the complaint wasn't about a hollowing out or a husk, I think, as my Lady Justice Asplin put it yesterday. It was about a diminution in value. And as it so happens, there wasn't...
What it actually says there, sorry,
yes, of course.
Since the interest is encumbered by the lease, isn't that the same point?
Well, what one has to read on, I think, the remainder of that paragraph. It says, since the interest is encumbered by the lease, its interest is less valuable than it would otherwise have been, which I think ties in with, as I say, the description of the complaint is more about the value of the interest itself, and that then feeds into the argument, I think, as I understood it at the time, as to why there was a conversion. And I just observe that at trial, and this is not, certainly not a criticism of South Bank, there was no valuation evidence, and the reason for that is because earlier on in the proceedings, the parties had agreed effectively to hive off the valuation issue. There was an order of Chief Master Marsh from February 2024, which my lords and my ladies won't have seen, but that's why there was no valuation evidence at trial. But suffice to say, that issue, whether or not the existence of the lease renders the freehold less valuable, is highly, highly contentious. We don't... I'm so sorry.
I'm so sorry, I'm just reading the rest of the 349, and the judge goes on at the top of the next page.
Yes.
I see a real difficulty with the arguments that SBHMC is seeking to recover an interest in the freehold when it's still got the freehold. So he is looking at the nature of the asset held, despite the fact I fully accept that there's the phrase about less valuable. He doesn't seem in that paragraph to be focusing on value.
Well, no, he's there focusing on the concept of what it is they are seeking to recover. And it's in that context, I accept he does seem to be looking at the nature of the interest. And the fact is that before and after the transaction, in my respect, for submission, quite rightly, the judge was correct to say that they held, South Bank held the freehold.
You had a freehold and you still got a freehold.
So, well, subject to arguments about the nature of the vendor-purchaser constructive trust. But all I would say is, I think what this court can't do is take it that there is, in fact, any kind of diminution in the value of the freehold by virtue of the lease. As I said, there's actually quite a number of sort of fairly complicated valuation issues that might arise in relation to that. Not least, in certain respects, the lease is quite valuable from the freeholder's perspective because it shifts certain liabilities. It shifts liabilities for repair onto the tenant, onto Lodgeshine, and also shifts liability for business rates onto Lodgeshine. So if the annex had remained unoccupied, Lodgeshine would have been the entity liable to pay rates for that annex. So I don't think what the court can't say straight away is, oh, well, it's definitely the case that this freehold has been hollowed out or devalued or denuded of any kind of financial.
Are there two things? One, we don't have to worry about this, as you say, it just doesn't arise. The other, so far as this may or may not matter, Mr. Conway obviously thought that there would be a diminution. I mean, the whole point of the scheme was to transfer value away from South Bank.
Respectfully, I think that's a non sequitur because Mr. Conway thought that the annex, as a, if you might loosely call a building, had some value because he could exploit it commercially. But it doesn't follow that if one grants a long lease of that part of the freehold out of the freehold, that the freehold of the whole site suffers a diminution in value. As I said, I don't think the court needs to get into that, but there are various reasons why, not least because of the way the scheme was structured and the limited use to which South Bank could actually have ever put, or indeed any third-party purchaser could have ever put the annex had it been offered on the open market. So, as I said, I'm not inviting, obviously, the court to get into that, but what I am saying is I don't think the court can accept, as my learned friend suggested yesterday, that there's been some vast diminution in the value of the freehold, because that, as I say, is highly controversial. And so, standing back, having put the case the way it put it at trial, in my respectful submission, it's a little bit unkind, perhaps a bit ungenerous to the judge, to criticise him for deciding the case in the way he did. And that then takes me on to the next point, which is how this case is being articulated on appeal. So we have to go back, I think, to ground one, which is page 17 of the core bundle. And the key bit of ground one is the final sentence, where it is said that the judge should have concluded that Mr. Conway had converted the freehold interest to his use by granting a leasehold interest out of that property to a company he controlled. Of course, in a sense, that's difficult to understand because Mr. Conway personally didn't grant anything. There was a grant by one company to another company. But leaving that to one side, if one keeps that complaint in mind, what the court needs to do is to see how that fits into the scheme of section 21(1)(b). And I think, or at least as I understand it, the way they try to fit this into 21(1)(b) is to say that this is effectively a permutation 2 case. So they say that this is an action by a beneficiary under a trust to recover from the trustee, in this instance that's Mr. Conway, trust property, which I think in this instance is a freehold interest, previously received by him and converted to his use, and the conversion arises out of the grant of the lease. So that's how I think one has to squeeze it into section 21(1)(b).
Just to be clear, does the previously received by the trust... I see.
So the previously received is, as director of South Bank, he is treated as legal fiction, if nothing else, as having received South Bank's assets. And what South Bank says is, as a matter of legal fiction, Mr. Conway previously received the freehold interest, and he converted that interest to his use, and he did that by granting the lease.
So the first bit of that must be the, at the time, the right to receive a freehold interest.
Well, that's obviously subject to, yes, whatever that, yeah.
So whether that, they say there's a constructive trust of that, you say there isn't.
Well, I would accept that as a director of South Bank, Mr. Conway was a constructive trustee in the proper sense of South Bank's assets.
Sorry, I was talking about South Bank holding the property under a constructive trust. Because it doesn't actually have the freehold.
That's correct. Yes. So exactly as my Lord Justice Newey said, there are two trusts. There's the vendor purchaser trust, which is between Galliard Hotels and South Bank, and then there is the trust of South Bank's assets as between Mr. Conway and South Bank. So those are the two trusts, and it's really obviously vitally important to distinguish between those two, and to see and to make sure that one doesn't end up eliding the two, as I venture to say South Bank has, when looking to get round limitation issues. So, as I said, this is a permutation 2 case, but importantly, if I can put it in a negative sense, it is not a permutation 1, 3, or 4 case. So South Bank is not suggesting that there is trust property still in the possession of Mr. Conway. Obviously, he's no longer a director of South Bank. That's permutation 1. But also, South Bank is not suggesting that there are proceeds of trust property in the possession of the trustee. That's permutation 3. And it's not suggesting that there are proceeds of trust property previously received by the trustee and converted to his use. That's permutation 4. And in my respectful submission, an important consequence flows from that, because South Bank is not asserting that the lease represents, in the wording of section 21(1)(b), the proceeds of trust property. Otherwise, this would be a permutation 3 case, or possibly a permutation 4 case. So, and I say the reason I think that's important is because any liability that Mr. Conway may have in relation to the lease doesn't depend on him having any pre-existing responsibility for the property which belonged to South Bank, at least not while he was a director of that company.
Sorry, can you say that again so I can get it down? Any liability Mr. Conway may have in relation to
the lease, it doesn't depend on him having what I might call a class 1 pre-existing responsibility for any property that belonged to South Bank. Because the lease, as is I think the logical consequence of South Bank's case on appeal, doesn't proceed or derive from any trust property. They're not suggesting that the lease represents proceeds of trust. So, my lords, my lady, that longer than I had wished, I apologise, deals with some introductory matters, and I'll now try and deal with the grounds really as quickly as I possibly can. So, let me take South Bank's ground 1 first. In my submission, the key point is there has been no conversion of the trust property for the purposes of section 21(1)(b). And in order to make good that submission, it's logically necessary first to identify what is the trust property that is said to have been previously received by Mr. Conway. And as we know, what South Bank looks to is the vendor purchaser trust under the freehold sale contract, the interest that is created that then belongs to South Bank. Now, since we are concerned with the freehold sale contract, it probably makes sense to look at that document. I don't think we've seen it yet, which is in the supplementary bundle at page 3. Just picking up a few provisions. Recital E contains a definition of income guarantees. And then recital F says, following the later of the last sale and the expiry of the income guarantees, it's intended that Galliard will transfer the freehold property to the management company for £1, and then there's a definition of sale date at the end of that recital. If we go on, please, to page 6 of the bundle, clause 6. It said that 5 working days from and including the sale date, Galliard shall sell and the management company shall purchase the freehold of the property for the sum of £1. So what we've got is an agreement taking effect in the future, that upon the happening of an event, the sale date, one party will sell and the other party will buy the property for £1. There's a further provision on page 8, clause 7, which effectively contains a long stop date. So in the event that the sale in clause 6 has not been completed by December 2013, then on that date, again, Galliard will sell, management company will purchase the freehold for £1. So what you can, just looking at the wording of the contract, what South Bank has under this agreement is a right in the future to purchase property for £1. Now, I think it is trite that all trusts have to have a subject matter. You can obviously have a trust of money, you can have a trust of land, trust of property, or anything else, I suppose. And that then leads you to ask, in this case, what was the subject matter of the vendor-purchaser trust at the date when the lease and the underlease were granted in 2008? Because that's obviously the critical date. So to answer that, I think we need to look at a couple of authorities. One is Jerome and Kelly, which I hope is in the Galliard Party's supplementary authorities bundle.
Just so I understand, I mean, in one sense, the subject matter is the property that's being sold. So you're making a different point.
Well, what I'm saying is that under the freehold sale contract, what South Bank doesn't get on any view, and hadn't certainly got as at the date of the lease and the underlease, as a beneficial interest of the freehold. What it had was a different type of interest, which was an interest in equity to seek specific performance of something.
But is that not just a standard vendor purchaser position? I mean, if you contract on day 1 to complete on day 28 in the interim period, that's the position. There's no difference, is it?
No, I think I would agree with that, my lord.
Yes, I see. And
the reason, obviously, it's important is because if South Bank doesn't actually own the beneficial interest in the freehold, the grant of the lease, as it were, it can't be a conversion of that trust property, because that ex hypothesi that's not the trust property, if that makes sense.
Depends on the meaning of conversion, I suppose. I mean, on any view, South Bank had a contractual right to the freehold in the future.
Correct.
So then there's a question as to whether, if you do something that affects that contractual right, you are converting the contractual right.
Yes.
Leave aside the Jerome and Kelly type point.
Yes. Well, it may be. I mean, in light of that, it may. If my lord is prepared to accept that, as at the date of the lease and the underlease, the beneficial interest in the freehold didn't belong to South Bank, then I don't need to spend any time.
And you better spend the time, because who's to say what we'll think at the end of the case?
Well, I just wanted to be very clear about
Yes.
that. And so I think I need to identify first what the subject matter of the trust is, and then I can perhaps try to explain why there's been no interference in the subject matter, whether it be a right to do something or whatever else it might be. So Jerome and Kelly is a tax case, and what's important, I think, is the speech of Lord Walker. He sets out the facts, picking up at page 10, paragraph 17. Shortly stated, you'll see there that members of a family own some land, and they contracted to sell the land to a company called Conda. And if one looks towards the bottom of that paragraph, completion was due to take place in May 1994. And if we then go to paragraph 19, you'll see that between the date of the contract and date of completion, there were changes in beneficial ownership of the land. Don't need to be too concerned in how that happened, but there were some transfers of some beneficial interests. And against the relevant taxing provision, there was consideration given as to the nature of the vendor-purchaser trust, which you can pick up at paragraph 29. Where Lord Walker says the Court of Appeal took the view that Mr Justice Park had wrongly ignored the general law of England as to sales of land, and in particular the significance of a contract for the sale of land being in general enforceable by the equitable remedy of specific performance. And if one jumps ahead to paragraph 32, what Lord Walker explains is that it would be wrong to treat an uncompleted contract for the sale of land as equivalent to an immediate irrevocable declaration of trust. And he describes how beneficial ownership is split, in a sense split, on a provisional assumption that specific performance is available, albeit that that assumption may be falsified. And then he goes on to say, at the end of that paragraph, towards the top of page 1420 of the report, if the contract proceeds to completion, the equitable interest can be viewed as passing to the buyer in stages, as title is made and accepted. And of course, if on exchange the purchaser acquired the beneficial interest in the freehold, it wouldn't have been open for the sellers in that case to alienate their beneficial interests during the period between exchange and completion. It's precisely because the buyers didn't acquire equitable interest in the freehold that the sellers were able to do that. The next case then I should refer to is Southern Pacific, which is in the Main Authorities Bundle, Volume 3, I think, tab 38. Now, this was a case concerning notorious sale and leaseback transactions. And essentially it was a competition between the sellers, the original homeowners, and the lenders who had lent money to the dishonest buyers to assist in the purchase of their properties. And the buyers' arguments were distilled in paragraph 27 at page 889. And between F and G, you can see argument number 1. At the moment of exchange, vendors each had an equity in their property, and then argument 2, the equity was a proprietary right, and what they were looking to do was to establish that proprietary right, or alleged proprietary right, in priority to the interests of the lenders. And in order to deal with those arguments, the court had to consider whether the buyers, so the wrongdoers, were in a position at the date of exchange of contracts to confer proprietary rights on the sellers. And we see, so then we can turn to paragraph 53, which is at 897.
This is a bit different from the normal vendor purchaser case, because just looking at that argument, this is a case where the vendor sells to a purchaser, but the purchaser gives an assurance that the vendor will then be entitled to occupation of the property after the completion of the sale. Is that right?
Yes, that's probably right. Yes, so they're promised you can stay there for however long, and then
So that it sort of goes through 2 stages. It's not quite like the normal vendor purchaser case where what one's looking at is the rights of the purchaser as against the vendor and whether that gives rise to any beneficial interest. This is a sort of reflexive thing where the vendor is saying, we entered into a contract for this whole transaction, and at the end of it, I'll have a right against you, the purchaser, to stay in the property.
not only against the purchaser, but also against third parties,
Right.
capable of binding third parties.
Yeah.
And so the key question was whether, on exchange, the buyers who had made all of these promises could have granted a proprietary interest of that type in favour of the seller. And in order to understand whether or not that was legally possible, you then have to consider the nature of the rights that the buyers acquire on exchange of contract. And hence why we get the discussion beginning at paragraph 53. And what follows is, as one would expect, an extremely learned discussion about the effect of a contract for sale. And perhaps if I could just pick up at page 898. Lord Collins identifies the question, which is whether a purchaser prior to acquisition of the legal estate can grant equitable rights of proprietary character.
Sorry, where are you reading?
I'm so sorry, my lady. Paragraph 60, 8
Thank you, got it.
And so that was the question that was before the House of Lords. And you can see then that Lord Collins, in the same paragraph, refers to the Englewood case that my learned friend handed up yesterday, and I'll come to that in a moment. And then explains the nature of a vendor-purchaser trust. And in paragraph 64 of page 899, Lord Collins refers to some observations of Mr Justice Dean in a case called Kern Corporation, where it's inaccurate and misleading to speak of an unpaid vendor under an uncompleted contract with a trustee. And then after that indented quotation, he references some High Court authority, High Court of Australia authority, that the description of the vendor as trustee conceals the essentially contractual relationship. And there's further discussion over the page. Given the time, I'm not going to take my lords and my lady to all of that now. But suffice to say, the outcome of the case is paragraph 79 at page 903. Where Lord Collins says the vendors acquire no more than personal rights against the purchasers when they agree to sell their properties on the basis of the purchaser's promises they will be entitled to remain in occupation. Those rights would only become proprietary and capable of taking priority when they were fed by the purchaser's acquisition of the legal estate on completion. And of course, that outcome wouldn't be correct if, on exchange, the purchasers obtained a beneficial interest in the property being sold. Otherwise,
well, that's right.
Well,
as between the purchaser and the vendor, I think what Lord Collins is saying is that there is a proprietary interest, so that the purchaser can enforce in all sorts of ways against the vendor, and indeed can enforce against third parties in certain circumstances. And he doesn't cast any doubt on that position as between the vendor and the purchaser. What he then goes on to say, however, is that those cases don't throw any light on the question whether the purchaser can grant rights to another party which are themselves proprietary in nature.
yes, I think I would respect.
So it's a very different situation, I suggest.
Well, I think I'd respectfully agree with what my lord has just said, and I think that really makes the point for me. It's right that as between vendor and purchaser, there is a right, a proprietary right that is capable of being protected, just as my lord has said, and indeed that happens in the scheme of land registration. And I've referenced a footnote in our two or three page supplementary skeleton, where what often happens is you put a notice of a contract in the charges register for a title, and that notice protects the right in equity to seek specific performance of the contract. And that rather tells you what the right is that you actually get when the contract is exchanged, as between vendor and purchaser. And when that right is protected on the register, exactly as my lord has said, it can then take priority over third parties. So if there's a disposition of the freehold, the priority is protected against the purchaser. But the second point, just again as my lord has said, is really reinforces the first point. The fact is that after exchange, the buyer, beyond the proprietary interest that is capable of protection, as I've described, doesn't have an interest, a proprietary interest in, let's call it the freehold, assume a sale of freehold, in the freehold, which it can then encumber by way of the grant of proprietary rights in favour of third parties, which simply reinforces the point that on exchange, what the buyer doesn't get is, quote unquote, an equitable interest in the freehold. The buyer gets something different, which is an equitable right to seek specific performance of a contract.
Well, I'm not sure that's where I agree with you, because I think what all of these cases which Lord Collins is dealing with, as between buyer and between vendor and purchaser, do talk about there being some form of proprietary interest, albeit it's a rather sui generis one, an unusual one. But he doesn't cast any doubt, as I read it, on that long line of authority which says there is some form of equitable interest. It's not just saying there's some sort of personal right to seek specific performance.
I think I'm agreeing with my lord, because the right to seek specific performance is, or at least at any rate can be, an equitable interest in land. For example, if you have an option to purchase or an option to renew a lease, that is an equitable interest that can be protected and is binding and capable of binding third parties. So if one is going to ask yourself, as at the date of the lease and the grant of the underlease, what is the subject matter of the trust? It is not the equitable interest in the freehold. What it is a right in equity to seek specific performance of a contract.
Can I ask a follow-up question? You said you make the point that a specifically enforceable contract of this kind can be the subject of a notice on the register. If this contract, the freehold sale contract, had been the subject of a notice on the register, what would have happened to the lease?
I mean, in a sense, nothing would have happened to the lease because, I mean, assuming, leaving aside questions about whether it was valid or anything else.
Well,
like
assume of itself it's valid,
yes.
but would it have been binding on South Bank?
Well, I would need to have a think about that because I'd want to have a look at the relevant provisions of the Land Registration Act, which could I have a think about that
Yes.
question over lunch?
So, I mean, as I understand it, you accept that if there's a notice, the vendor can sell the freehold, but the first purchaser won't be bound by the second sale. Is that right?
Yes, so I think the way it works, I'm just reminding myself in my own mind about, I think it's in section 29 of the Land Registration Act, how the priority rules. But I think what happens is that the priority of a disposition is unaffected by any prior interest unless that interest is protected. And so if an interest is protected by notice under 29(2), I think it is possibly, then the registrable disposition, if made for valuable consideration and what have you, then won't take priority over that protected interest.
So if Galliard Hotels had simply sold the site, South Bank could say, who cares, assuming that the contract had been on the subject of protection on the register.
Yeah.
Why wouldn't it be the same if Galliard Hotels had granted a lease? Why couldn't South Bank equally say, well, who cares, we protected our contract on the register?
Well, I suspect that is the position. I mean, I said I just want to double check, looking at the relevant rules, but I would be surprised if the position was any different.
So just to be really unfair, one might say all Mr. Conway had to do to protect South Bank was get it to put a notice on the register.
Well, yes, I suppose. I mean, insofar as he wanted to protect South Bank's interest under the freehold sale, yes, I think I would accept that. But of course, I mean, for what it's worth, I mean, that's not a point that was ever pleaded or taken at trial. But yes, I mean, I see the force of that. See if because except that's the interest that would have been capable of protection, and certainly what one doesn't protect, and indeed one can't protect by notice under the Land Registration Act, is a beneficial interest under a trust, which is why you protect the interest under a contract with a notice. It's a different type of interest. It can't be the beneficial interest of the freehold. Can I just, conscious of the time, can I briefly refer to some of the authorities handed up by my learned friend yesterday in the blue zigzag file. Starting with Snell. Page 23 of the bundle. My learned friend took my lords and my lady to the second paragraph, which describes how a vendor purchaser trust has two functions. First, as against the vendor, it serves to impose certain duties. And that's important, as we'll see in the Englewood case. And then the second, I think this picks up on the debate I had with my Lord Justice Miles, is at its effect against a third party. By treating the purchaser's contractual right as an equitable interest in the legal estate, the priority of the purchaser's right to a conveyance is preserved. And my learned friend didn't read on the final sentence. The justification for giving the purchaser these additional rights is that the contract is specifically enforceable. And that's if you like, the justification or the rationale for why you have that particular type of equitable interest. Then my learned friend took you to the Englewood case. Just very briefly on that. I think it's important to put the various observations in context. So if we could go to page 4 of the bundle. In that case, there was a public auction, paragraph 2, of certain shops in Essex. And lot number 11, this is paragraph 3, defined as the property, was basically a Woolworths store. And paragraph 6, Mr. Patel bids for that property successfully. If one goes over the page, paragraphs 9, 10 and 11, the property was originally subject to various leases. We don't need to worry too much about the detail of it, but suffice to say, if one goes to paragraph 13, there was a particular covenant just after letter H, 3 lines down. The lessors will in every conveyance or lease of any such shops or any part thereof insert an appropriate covenant to prevent the purchaser or the lessee ... from selling or letting any such shops to any person whose primary business is that of a fixed price store. And if one goes to then paragraph 17, the buyer's solicitors, this is between letters F and G, asked Englewood's solicitors to confirm that in respect of each lot, a covenant not to let the properties was to be imposed on the buyers of the other lots. And Englewood wouldn't do that, and so the buyer refused to complete, and Englewood sued for specific performance. And if one looks at paragraph 25 on page 7, Mr. Patel asserted that there was a breach of duty on the part of the seller by failing to insert covenants or conditions in the agreement for sale relating to other lots that would protect him as buyer of the property. So that was essentially the complaint. And then you can see at page 10, paragraph 32, what the principal issue was between the parties, whether the trustee's duty could extend to a duty to impose covenants on purchasers of adjoining properties. We then get the discussion at paragraph 40 onwards that my learned friend took you to yesterday. And that includes the Heronsgate case, which references, as my Lord Justice Newey pointed out yesterday, certain trust obligations. For present purposes, I think what's important is to pick up at page 15, paragraph 44, which sort of, in a way, echoes or mirrors what's said in Snell, where Mr. Justice Lawrence Collins divides the cases into 2 categories. The first is where the existence of the trust or the identification of the trust property is in question. So that's what we're concerned with. And then if one goes over the page to 16, the second category of case relates to the scope of duty of the vendor as trustee. And it's in that second, and so this was a second category of case. We were in the question as to what the duties of the trustees were. So this case was not concerned with the subject matter of the trust. And then it's in that context that we get on page 18, paragraph 54, some discussion about the duties imposed on the vendor. So that would, in this example, that would be Galliard Hotels at the time of the contract. So you see it by letter E. on paragraph 54, the vendor can't or should not relet the premises. That's nothing to do with the subject matter of the trust. That's just something conceptually different, which is what are the true nature, what are the responsibilities of a trustee under a vendor-purchaser arrangement, independent of the subject matter of the trust itself. And so in my submission, that case doesn't really assist us.
I'm not sure this matters, but is it entirely divorced? I mean, if it were in truth the case that contractually there was a right to grant leases, then there could be no question of registration or putting a notice on the register debarring the vendor from doing that. The subject matter of the trust, if we're going to call it that, would be affected by the contractual terms.
Yes, I think that, I mean, I was probably expressing myself very poorly, but I think the point I was trying to convey is that juristically there is a distinction between, if you like, the obligations on the part of the trustee either not to do something or to do something, which is juristically independent of, albeit I can see conceptually going to be informed by, the subject matter of the trust, which is the second type of thing. And what we're concerned with in this case is not the first thing, the duties of the trustee, because in this example, the duties of the trustee are Galliard Hotels as the vendor. Mr. Conway owes no duties as a vendor because he wasn't the vendor. We're concerned with the question as to, well, what interest does South Bank get in 2008 when the lease and the underlease are granted? And so with all that in mind, I think I try and boil down my submissions, I think, to this point, is that the vendor-purchaser trust is a very unusual type of trust. And what you have is essentially a contractual relationship, but equity has historically recognised that certain interests under that relationship need protecting. So you have the purchaser's interest in receiving the land, and that interest is protected by specific performance if necessary. And you also have the vendor's interest in receiving the purchase monies, and that's typically ensured by an unpaid vendor's lien. So those are the interests that are protected. And properly understood in my submission, it's those equities which form the subject matter of the vendor-purchaser trust. And indeed, you might think it would be inapt to suggest that the property itself is held on trust immediately on exchange, for the simple reason that the purchaser's right to call for specific performance leads to the enforcement of contractual terms, the conveyance, and then obviously the registration of title. Why is that then important? So it's important because as at the 16th of June 2008, when the lease and the underlease were granted, what South Bank had was a future entitlement to specific performance of a contract on Lord Walker's provisional assumption that it would be available either at the sale date or the long stop date. And that entitlement is the trust property which, as director of South Bank, Mr. Conway is deemed, in legal theory at least, to have received. And in my submission, there has never been any conversion of that right or entitlement, even in the extended sense that my learned friend argues for. On the contrary, the freehold was subsequently sold. I don't know whether £1 was in fact paid, but it was subsequently sold and conveyed. The right to specific performance was never taken away, ever. And one can test it this way. Suppose that South Bank had sued for specific performance the day after the lease and the underlease had been granted. Why wouldn't it get it? it may be entitled to damages against Galliard Hotels for breach of its obligations under the contract. In another sort of case, you might get an abatement in the purchase price, but you still have the right to specific performance. And my learned friend's answer to that is to say, well, even then there's been a conversion of the right to specific performance because you're not getting the unencumbered freehold. In my respectful submission, that elides two different things. It elides the right to specific performance, which is properly understood the subject matter of the trust, which is capable of being protected, and the subject matter of the right itself, which is something completely different. So that's what. Yes, of course.
Supposing that on the 1st of June 2008, suppose South Bank had been in different control by that stage. Could it have applied for an injunction to stop the lease being granted?
Well, on the assumptions that what was being threatened at that stage, because of course the lease and the underlease were not granted until 16th of June.
So just before.
Just before. So
take
just before.
Take the 15th of June.
Yeah. Yes. So the day before, South Bank, under completely independent control, gets whiff of the idea that a lease was going to be granted. I see no reason in principle why they couldn't have applied.
Sorry, no reason in principle why
no,
they
in
couldn't.
principle that they could not apply for an injunction. I suppose on the basis that the threatened grant of a lease would result in a breach of the contract, and so they might apply for some sort of quid pro quo relief or similar. I mean, I suppose if there was some kind of fraudulent conspiracy or an economic tort, they could also, once the lease has been granted, seek an order for the surrender of the lease. Like there's I think case Tesco
Really
and Crest.
imagining in advance,
Yeah.
just on a contractual basis, essentially.
Yeah. I think so. I think I would agree, accept that. So if I'm wrong about identifying the correct trust property, then as my primary argument, then I'll have to deal with the question whether, well, let's suppose the trust property now, for the purposes of section 21(1)(b), is the beneficial interest in the freehold, which is, I think, how we had sort of formulated the argument originally. In my submission, even then, the grant of the lease, so the creation of a new interest in land, can't, in law, amount to the conversion of a different interest in land for the purposes of section 21(1)(b). And it is certainly not the case, as my learned friend submitted yesterday, that the Land Registration Act regards the grant of a lease as a disposition of the freehold. And we actually have copies here of some provisions of the Land Registration Act. Maybe I don't even need to take you to them, but the grant of a term of years is its own type of disposition in section 27 of the Land Registration Act. I mean, it may help perhaps just briefly to hand this up. And just turning to tab 3, the Land Registration Act, section 27(2), identifies various what are called registrable dispositions. You can see in section 27(2)(a), one of those is a transfer, and then B, where the registered estate is an estate of land. the grant of a term of years absolute, and then there are various different types of grants you can have. But I simply draw that to my lord's and my lady's attention.
Does that not mean that the grant of the lease is a disposition of the registered estate?
The grant of a lease is itself a registrable disposition.
I follow that, but is it not a disposition of the registered estate?
No, my lord. It says where the registered estate is an estate in land. So if you have an unregistered title, then the grant of a lease is itself not going to be a registrable disposition. So this is dealing with registered land. So where you have a registered title, and then you have the grant of a lease.
I think I'm being stupid, and I ought to read this properly, but it says, subsection 1, if a disposition of a registered estate or a registered charge is required to be completed by registration. So you're dealing with a disposition of a registered estate.
Mm-hmm.
In the case of a registered estate, the following are dispositions which are required to be completed: either a transfer of the estate or the grant. Yeah, you're probably right.
Maybe I'm not, but anyway, as I understand it, at least my reading of section 27, and I don't want to get down this rabbit hole in a way because it's sort of slightly peripheral relevance, but it was simply to meet the point that my learned friend made yesterday, which is that the land registration doesn't regard the grant of a lease as a disposition of the freehold. A disposition of the freehold will be a transfer, I would have thought. But anyway, what section 27 also teaches us, I suppose, is that the grant of the lease is its own type of disposition. And so at a most basic level, what you have is a freehold interest which remains the freehold interest before and after the grant of the lease. Albeit after the grant, it is subject to and with the benefit of the lease. And I don't accept, respectfully, and indeed it wasn't suggested at trial, that the grant of the lease somehow renders the freehold a husk. And that goes back to the point we've already discussed about the issue of value and so forth. On this subject, my learned friend, in his skeleton argument, referred to the Pantone case, but didn't say anything about it orally. So I'm not going to say anything about that case either. But he did discuss the Haysport case, which is in volume 3 of the authorities, picking up at page 911. Tab 40. 991, I'm so sorry, I said 911. Now, in very broad terms, what happened in this case is that there were these two companies, one called Twin Setra and one called Haysport, and they were owned by a charity called Delepage. Separately, there was a trust called the NOF Trust, of which Mr Ackerman was a beneficiary, and that trust held shares in another company called New Liberty Property Holdings. And that company was interested in a development opportunity and took out a loan with Lloyds for about 10 million quid, I think. And the two companies, Haysport and Twin Setra, provided security for those borrowings. In addition, Twin Setra made a loan of £4 million to the development company to enable the acquisition of a portfolio. And if one looks at the, picks up at page 38 of the report, it's page 999, paragraph 38. The judge there describes how Mr Ackerman was sued as a director of the Claimants for breach of fiduciary duties that he owed in that capacity by risking what was essentially charity money for his and the other company's private benefit, and did so by granting security and causing Twin Setra to lend the £4 million. And you'll see what the claimants were seeking in paragraph 43 was repayment of the 4 million plus an indemnity. And it's in that context that we get some very compressed reasoning relating to limitation at page 1009. In paragraph 105, Mr. Justice Peter Smith records the claimant's submissions. So 105 sub 3 says they contend that. So that's what the claimants were arguing. And then we get this very, very brief decision at paragraph 106. Accordingly, in respect of claim 3, I'm of the opinion, following Pantone, the transactions involved handing over property of the claimants to a company in which Mr. Ackerman was interested. It's very, very hard to discern from that judgment whether Mr. Justice Peter Smith thought that the grant of the securities in favour of a bank represented the conversion of trust property to Mr. Ackerman's use. And it might be thought rather difficult to see how that could be the case, because of course the securities are in favour of a third party. So in my submission, the Haysport case doesn't really advance South Bank's arguments in this appeal. As a final observation on this subject, yesterday my learned friend referred to the Axminster case, which is behind tab 51, I think, in volume 4. So, my lords and my ladies, in particular to paragraph 156.
Sorry, you're going to give me the page number again, please.
1535, please.
Thank you.
Paragraph 156. And my learned friend took my lords and my ladies to the sentence 4 lines down, beginning the only argument raised by Mr. Legg, etc. And referring to that sentence, what my learned friend submitted, and this is the transcript from yesterday, it's on page 44, was that section 21(1)(b) is engaged, as my learned friend put it, where the beneficiary never had a proprietary interest in the trust property before or after the breach of duty. And in my respectful submission, that's to misunderstand what is said in this paragraph. And the crucial words are at the end of the sentence, in the subject matter of the claim. So what a beneficiary doesn't have to show is a pre-existing proprietary interest in the subject matter of the claim. So take, for example, a situation where a company director just steals company money and spends it, so it doesn't exist anymore. You could have a claim for the recovery of trust property within section 21(1)(b), which would essentially be a personal claim against the director to compensate the company for the loss. But necessarily in that example, the company doesn't have a pre-existing proprietary interest in the personal claim. It's a personal claim. And the property of the company has since been dissipated. So I think that's the only point, I think, that... So
the company has a pre-existing claim in the money, because it owns it.
But the money isn't there anymore. So because...
Then the claim is for the recovery of the property, and that phrase is taken to include a claim for damages or compensation.
Yes, so the subject matter of the claim, as I read paragraph 156, is the claim for compensation. And in respect to that, the company doesn't need to have a pre-existing proprietary interest.
I haven't properly understood the context of all this. This was a pension scheme case. The question was, did beneficiaries of the pension scheme have claims potentially for arrears that they should have been paid out of the scheme?
Yeah, so to contextualise it, if one goes to page 1510, you see what the issue was in paragraph 55. There's a bold heading, limitation, and it says, is a claim by a member or other beneficiary under the plan to arrears of pension increase payments subject to a limitation period under 21.3 or 21.1b. And then that issue is addressed at page 1512 under the heading Issue 1, Section 21 of the 1980 Act. And there follows obviously an extended discussion about that issue. And so far as the beneficiary's rights are concerned, at page 1515, paragraph 71,
So even though the beneficiaries are beneficiaries under a trust, it's accepted they don't have proprietary rights and don't have.
yes, it was conceded, although paragraph 72, I think Mr Justice Morgan thought actually, whilst the beneficiary under this pension scheme didn't have a proprietary interest in a narrow sense, it did have a proprietary interest in a broader sense.
Yes, I see.
It's rather like those cases about unadministered estates and so on, isn't it? Where the beneficiary has a right to require the trust to be properly administered, but doesn't have a proprietary interest in any particular asset.
Yes, or the object of a discretionary trust.
Yeah.
It doesn't.
So
yeah.
so when he comes to this passage of 156, isn't that really the argument that's being addressed there, that the beneficiaries are in that sort of position, i.e. they don't have that kind of interest in the assets before the claim is brought, as it were. And that seems to be a bit different from the case you gave an example of, which is where the company has some money, where there's no doubt that the company owns the money, and then the director spends it. That doesn't seem to have anything to do with the point that's being made here.
And at 155, of course, as my Lord Justice Myers points out, there's a discussion about Green and Gore, which was a case for an unadministered estate.
Yes, so, well, as I read paragraph 156, Mr Justice Morgan begins, I explained earlier that I would, in the first instance, consider the operation of section 21(1)b in relation to a claim by a beneficiary against the trustee for an account and an order for payment of a sum of money to which the beneficiary was entitled under the terms of the trust. And then he goes on to say, the only argument raised by Mr Legg as to why such a claim was not within section 21(1)b was that the provision required the beneficiary to show that it had a pre-existing proprietary interest in the subject matter of the claim. I'm not able to find any words in section 21(1)b which impose that restriction on its operation. And then he goes on to explain, a few lines down, I find that a claim by a beneficiary against the trustee for payment of arrears of pension would be an action to recover from the trustee trust property, and it being admitted to the trustee that the trustee is in possession of the trust property, the beneficiary is able to rely upon section 21(1)b. So, as I said, as I read that, I think what the judge was concerned with was, as he put it, the subject matter of the claim. And in the example he gives, it's a claim for an account and an order for payment of a sum of money to which the beneficiary was entitled under the terms of the trust. But anyway, that's I think all I wanted to say on that. I'm not sure that the debate yesterday on Axminster necessarily progressed matters anyway. But there we are. My Lords, can I move on then to what is my ground 1A, which I think is probably logically the next to consider, which is which is this. So, assume I'm wrong on everything I've said so far. There's then a question as to the capacity in which Mr. Conway is being sued. And my essential submission is that as regards the lease, one has to bear in mind that the ground of appeal presupposes that the lease is as it were the wrong, because that's the expression the expression of the conversion. As regards the lease, my submission is that Mr. Conway is not a Class 1 trustee caught by Section 21(1)(b), and South Bank's submissions, I would venture to say, run contrary to the Gwenby case and the first Subsea case, which I'll take you to in a moment. Just taking a step back, this submission, I think, ties in closely with a point I adverted to earlier, which is the importance of the action and that word within Section 21(1)(b). As my Lord Justice Miles said yesterday in an exchange with my learned friend, the concept of a conversion in Section 21(1)(b), I think my learned friend accepted this, connotes some kind of legal wrongdoing. And as Lord Justice Miles also put it to my learned friend, and I think, again, my learned friend accepted this, it's all in the transcript from yesterday on page 49, that wrongdoing must involve a breach of duty by the trustee, or what we might call the relevant trustee. So can I then start with the Gwenby case, please, which is to be found in the authorities bundle behind tab 29, which I think is volume 2. Pick up the judgment of Lord Justice Nunnery at page 561. And in paragraph 2, you'll see reference to a company called GVDC, the Zambian company.
Sorry, I wasn't keeping up. Which page are you on?
Page 561, paragraph 2. And you'll see reference, second line up from the bottom, to a company called GVDC. And then if we go to the next page, paragraph 5, the relief claimed in the GVDC action included an account of profits made by its MD, Mr. Koshi. Claims were made against him for equitable compensation for breaches of fiduciary duty, damages for deceit, and so forth. And then if we go over the page to 563, at the top of the page you'll see reference to an appeal numbered 0090. Mr. Koshi appealed against the order directing him to account to GVDC for unauthorised profits. And one of the points raised on the appeal, and this is just before letter C, was that the judge ought to have held that the claim for an account of profits was statute barred. If I can take you, please, to the next page, 564. Paragraph 13. There's reference to an investment in GVDC being made through another company controlled by Mr. Koshi called Lasco. And GVDC acknowledged a debt of $5.8 million payable to Lasco arising out of certain transactions. And we get detail of those transactions on page 565. I don't think I need to take you through the detail of it. Suffice to say, if one looks at paragraph 21, you'll see that the essential complaint is that Mr. Koshi, through Lasco, arranged an advance for a certain amount of Zambian currency, which cost Lasco $1 million US. But I think at the rate of exchange was worth $5.8 million or something like that. And then so you can see at page 566, paragraph 24, 3 lines up from the bottom, that Lasco made a profit of $4.8 million on this transaction. So the central allegation against Mr. Koshi then features at page 567, paragraph 26. Where it was said that Mr. Koshi had breached his fiduciary duties by procuring the BBC to enter into the transactions for his own purpose. Their effect was that Koshi and Lasco could treat GBVC as liable to pay $5.8 million on demand. So that was the central allegation. And if one goes to paragraph 43 of the judgment on page 570 through to 571, you'll see that Mr. Justice Reimer held Mr. Koshi liable to account. And he held him liable to account in one of 2 ways. For our purposes, the first way is the only relevant way. Under the no profit rule, company director may not make an unauthorized profit. And then rule stems from the general principle that a director must avoid conflicts of duty when discharging fiduciary duties undertaken by him in the management of the property beneficially belonging to the company and in pursuit of his personal interests. So that's how he was found liable. There then, later on in the judgment, follows quite a lengthy discussion on limitation, and that begins on page 577. At paragraph 71. And I'm going to skip over quite a lot of that and pick up, if I may, on page 582, paragraph 90. Lord Justice Mummery, anticipating the Williams and Bank of Nigeria case, identifies how 2 classes of trust and fiduciary duty are treated differently. And perhaps can I just invite you please to read paragraph 90.
Just to set another hair running irrelevantly, in the Court of Appeal in Hotel Portfolio, is it called, where we were subsequently reversed by the Supreme Court, I did to an extent grapple with Graham Valley. And I'm not sure that what I said about Graham Valley was actually the subject of criticism in the Supreme Court. I can't entirely remember what I said, but I think it might have been related to some of this stuff.
Well, we can obviously look. We'll look at that.
Yeah.
See if it has any bearing on my submissions. So, but yes. Anyway, perhaps if I could just invite you to read paragraph 90. And then picking up, please, at page 584, paragraph 101, there is a discussion about how Lord Justice Chadwick, in an earlier case called Harrison and Harrison.
And definitely I was worried about Harrison and J.J. Harrison in Hotel Portfolio, and that bit, I think, was accepted in the Supreme Court.
Well, I'm grateful for that. I said Harrison and Harrison was a case where I think a director just transferred land to himself, if I'm not mistaken. But what I'm interested in at this stage is how Lord Justice Chadwick in that case treated another case called Taylor and Davies, which was a decision of the Privy Council. And you can see there that in that case, the defendant was an inspector appointed under an insolvency statute to oversee assignments for the benefit of his creditors. Although by virtue of his position, he could not rely upon a transfer made to him without his having made full disclosure to the creditors, he had a limitation defence because he was not a trustee of the property within the meaning of the relevant statute. And then we get a quote from a passage of Viscount Hill, the Lord Chancellor. And can I just invite you, please, to read the indented quotation, and in particular, the bit after C going to the end of the quotation.
Meaning it followed that.
From but to the position in this respect.
I
Just
see.
after that,
Yes.
where you get the emphasised text. And then we get to paragraph 102, where Lord Justice Mummery comments on Lord Justice Chadwick's comments on that decision. And Lord Justice Chadwick analysed it as follows, and this is the second indented quotation, where he recognised that the Privy Council rejected the submission that the defendant fell within the first category of constructive trustee. He fell within the second category. And then a couple of lines on from that, a very important passage I would suggest. The reason why he was not within the first category is he did not have the power to dispose of the company's property. That power lay in the assignee, subject to the supervision of the inspectors. Thus, he goes on to say, the defendant in that case, although in a pre-existing fiduciary relationship with the company, was not himself the custodian of its property. And then trying to apply those principles to the facts in Gwenby, you can turn to page 587, paragraph 101. Where 3 lines down, Lord Justice Mummery said the starting assumption should be a 6-year limitation period. Then at the top of the next page, personal claims against fiduciaries will normally be subject to limits by analogy, etc. And then paragraph 112, he explains why Mr. Koshy was within section 21, which is directly a company director. And so, as he puts it, the question at the end of paragraph 112 was whether the 6-year time limit was excluded. And Mr. Justice Reimer, you can see at paragraph 113, thought that the claim did fall within section 21, 1B. And the Court of Appeal disagreed. And we see why at page 589 of the bundle, paragraph 118. And I place particular reliance on sub-paragraph 2. Mr. Koshy's personal liability to account to GBDC for profits made by him from his fiduciary position as a director is not dependent on establishing that he's received any money or other property belonging to GVDC as a result of the misapplication of GVDC's assets. And it goes on to say GVDC's causes of action against Mr. Koshy were based on the equitable disabilities or the fiduciary duties to which he was subject as a director of GVDC. As such, he was under a personal liability in equity to account for GVDC for unauthorised profits, either because he was disabled in equity from making a profit, personal profit out of the position occupied by him, and or because he acted as a dishonest breach of fiduciary duty. And just pausing there, exactly the same can be said about Mr. Conway in his capacity as director of South Bank. Then we go to the next page, Roman 3. Conversely, his fiduciary position as director of GVDC and the liability which results are quite separate from any responsibility borne by LASCO as manager of the project, or Mr. Koshy as its agent. And there is described how Mr. Thompson presented a number of elaborate arguments designed to establish that Mr. Koshy's failings invalidated the whole of the LASCO arrangements. Alternatively, all payments made by LASCO from GVDC were misapplications for which Mr. Koshy was liable. And that's rejected because LASCO had a valid role between C and D. And by letter E, you'll see the only thing wrong with them, that's the payments, was Mr. Koshy's failure in his separate capacity as director of GVDC to make full disclosure to that board of the nature and extent of his financial interest. And therefore, paragraph 119, 120, it's clear that any trust imposed on Mr. Koshy is a Class 2 trust within Lord Justice Millett's categorisation. That's Gwenby. 5 minutes before lunch, I'm happy to make a start on first subsea, or perhaps break there.
Since we haven't got that much time, why not make a start?
Okay. So this is first subsea is to be found. I think it's at tab 42, which is volume 3. Trying to really deal with this as quickly as I possibly can. Can I take you please to page 1032 of the bundle, paragraph 4. The judge, sorry, Lord Justice Patton, excuse me, sets out what the issues were for the Court of Appeal, 1, 2, 3 and 4. And you can see issue number 3 is whether section 21(1)(b) applied. As it happens, the Court of Appeal decided that the case fell within section 21(1)(a), so it didn't need to consider 21(1)(b). But nonetheless, it makes some pertinent observations about section 21(1)(b). In terms of the facts, just again to try and put the case in a bit of context, you can see in paragraph 6, 3 lines up, there's a company called BSW, and then in paragraph 7, Mr. Emmett and Mr. Walmsley sell a big stake in that company to another company called Arnley, which is owned and controlled by someone called Mr. Sutty. And then after that, a guy called Mr. Brown, still in paragraph 7, becomes the managing director of the company. Over the page, paragraph 9, Mr. Brown gets dismissed for gross misconduct and he's replaced by someone called Mr. Hatfield. And then paragraph 10, it's clear that by 2004, Mr. Emmett and Mr. Sutty are having a big falling out. Paragraph 13, before the falling out, back in 2003, there had been a discussion between Mr. Emmett and Mr. Sutty about the possibility of getting some work from a French company called Technip in connection with something called the Dahlia project. And then paragraph 15, July 2004, so this is again after the falling out, Mr. Emmett and Mr. Brown, the erstwhile managing director, submit tenders for the Dahlia project, knowing that the company BSW was also bidding. And then paragraph 15, I'm still in that paragraph, 20th of July 2004, Mr. Emmett resigns and then incorporates a company called Baltec, along with someone called Mr. Halstead. And then you can see from paragraph 16 that one of Baltec's bids was successful and it was awarded a contract. And it bids also, quite aside from poaching a contract, its bids had a depressive effect on BSW's original tender, because BSW had to adjust its tender down to make it more competitive. So it was kind of like a double hit, if you like. If we jump to paragraph 25, I think it is on page 1037. The judge's findings, and this is by letter H, were that Mr. Emmett had acted in breach of fiduciary duty by preparing and submitting bids.
Sorry, where do we see that?
By letter H, the preparation and submission of the bids for the three contracts were, he held, different.
Yeah.
And then you'll see what Mr. Justice Norris said in the indented quotation, second line down. He chose to promote his personal interests over loyalty to BSW, etc. And it's in that context, as one can see at page 1038 going into 1039, paragraph 28, that the Court of Appeal had to consider whether section 21(1) applied. And perhaps on that cliffhanger, just before 1 o'clock.
I'm just wondering, how long will it take us to complete the case? Would it be better to complete the case before we break?
I'm very happy to do that. It might take maybe another 5-6 minutes there.
I think, unless there are objections, let's complete the
Very
case.
So that then leads to the extended discussion about section 21, which begins at paragraph 32, page 1040. And you'll see that Lord Justice Patton there records how the judge rejected BSW's submissions that the case fell within 21(1)(b on the grounds that there had been no wrongful dealing with Mr. Emmett with pre-existing assets of BSW. And the explanation for that between B and C is that the claim was run at trial as one for damages for conspiracy. There was no proprietary claim in relation to the property of BSW. And can I just please ask you to read the indented quotation after letter C? So what the judge then did per paragraph 33 was nonetheless to hold that Mr. Emmett was liable and the case fell within 21(1)(a) because he had acted fraudulently. At paragraph 34, there's reference to a particular controversy under section 21(1)(a), which I don't think applies, followed by a discussion about Paragon and Thackeray and the distinction between Class 1 and Class 2 trustees. And if we then pick up, please, at paragraph 41, on page 1044, there's a lengthy quotation from the Paragon case, which I don't need your lordships and lady to read now, But at the bottom of page 1044, there's an important observation. These passages recognise that the gateway to section 21 is the definition of trust and trustee. The protection afforded to beneficiaries depends upon the status of the defendant at the time he commits the breach complained of. And that ties in very, very closely with, if one goes a little bit further up the page, indented paragraph 9 by letter G. Lord Justice Millett describes how any principled system of limitation should be based on the cause of action, not the remedy. Now, those points feed into a submission that was made by counsel for Mr. Koshy, sorry, Mr. Emmett, I think I'm so sorry, at paragraph 47, page 1048. Where it was said that the position is less clear when the director's breach of duty doesn't involve the misappropriation of company property, but is a fraudulent breach of duty which, if committed by anyone but a Class 1 fiduciary, would give rise to a constructive trust of the Class 2 kind. Mr. Cavender's argument is that Section 21 has no application to the second type of case, even where the fraudulent breach is out of a Class 1 fiduciary. It's limited to cases where the fiduciary misappropriates or misuses property already vested in him or under his control. The focus of Section 21 is on the nature of the cause of action, rather than the identity of the person who commits the wrong. And then that follows into the next page. This is then gives rise to some discussion and analysis of the Gwenby case, picking up at page 1050. Paragraph 53. Where Lord Justice Patton explains why the claim against Mr. Koshy didn't fall within Section 21(1)(b. And then in 54, describes how Mr. Koshy had not received any pre-existing company property, and quotes from a passage from Gwenby that we've already looked at. Then, probably, if we pick up then at page 1051, paragraph 56, there's reference to a case called Holton International, where, which has some sort of generic similarities, I suppose, with the present case. It concerned the exercise of voting powers under an agreement. Defendant had been appointed to act as attorney for shareholders for the purposes of negotiating a franchise. He used the voting powers to increase the issued share capital of the company and in effect dilute the claimant's shareholdings. His actions were said to constitute breaches of fiduciary duty. The claimant sought the transfer of a proportion of the newly issued shares. The Court of Appeal held that the claim is statute barred because any trust which existed in respect of the new shares was of a Class 2 type. It arose solely as a consequence of the alleged breaches of fiduciary duty. And that's really important. It arose solely as a consequence of the alleged breaches of fiduciary duty. Defendant was not therefore a trustee within the meaning of Section 21, and 21(1)(b) had no application. And so Houghton, per para 57, is a conventional application of Section 21. And then finally, said I'd be 6 minutes, but I'll jump up there. Paragraph 59, Lord Justice Patton explains that the provisions of Section 21(1)(b) have no application to cases like the Gwenby case, where there's no misappropriation or receipt of pre-existing company property, but only a breach of duty, which gives rise to a constructive trust, for example, over the secret profit. This is because, in such cases, the director is not a trustee virtute officii in respect of the profit. He has no proprietary interest with what he acquires, other than that as other than as the recipient of the proceeds of his breach of duty, and so forth. My Lord Somali, on that
Yes.
note, I had quite a lot to deal with.
We'll break now. I think we'll just start again at 2 o'clock rather than losing more time.
I'm grateful. Thank you.
Court rise if able.